bill today, and this is House Bill 772. Yesterday, we had moved to a place where we were considering a favorable motion on 772. There was an indication that there could be an amendment. I'm going to ask the Vice Chair if he would retract his motion for a favorable for the moment so that we can take a look at the amendment. So motion to retract, you know, I think he's just going to do it, but second is fine. So we're going to just take this back. And I believe that Delegate Schmidt has an amendment. Delegate Schmidt, would you like to describe what your amendment does?
Thank you, Chair. Thank you, members of the committee. This is an amendment regarding House Bill 772, also cross-filed with Senate Bill 540, amendment number 893322-1. It's got a striking recovering on page 1 on line 9. You have the amendment there, and then also amendment 2 as well. So this is regarding some language in the bill regarding the obtaining the certain manner. So the investigation litigation costs in a certain manner. So everyone received the email, I believe, from Andrew Griffin regarding some of the thoughts behind that. So with employers and already subject to injunctive relief, damages, fines. We talked about a lot of this yesterday, so this kind of strikes some of that language to help the bill a little bit. So it still gives the AG the permission to do it, just strike some of the certain restitution in a certain manner.
And so what this would do is, so that my understanding is the Attorney General doesn't get to claim the costs or the restitution or anything else unless they win the case. Is that correct? Looking at Delegate Embry nodding vigorously, is that, she can't speak to the Office of the Attorney General, but is that correct? That's my understanding, that they don't get these unless they win, right?
Correct.
Okay. So I guess the question that I had was on the amendment, and I did hear from people from the chamber, and I'm happy to hear from them, but effectively, it seems like what underlies this is that there's a lack of certainty for businesses who could potentially fall afoul of this statute, and they would like greater certainty, so they'd like to know exactly what the costs would be if they are found to be guilty of a civil rights violation?
I think the way that I understood was more parameters around the amounts. I mean, I don't think they're going to weigh their options of, is it going to cost $5,000, $10,000, $20,000? I think just making sure that we have certain parameters around what that could look like.
All right. I'll go to Delegate Bartlett. Well, let's do this. You're making a motion on the amendment? Motion. Okay. Is there a second? Second. All right. So now we'll discuss the amendment. Delegate Bartlett.
Thank you, Mr. Chair. My problem with the amendment is that it doesn't do that, which was just stated. What it does is take away all of the ability to reimburse the OAG's office the cost of the investigation and litigation. It does that because it doesn't. I think that if we were talking about what's in the email, we would have truly put parameters and said up to X amount of dollars, or we would have said, you know, up to X amount percent. But in fact, what we're doing is striking the ability for the reimbursement in its entirety. So that's one of the reasons why I have problems with the amendment, because it's not quite it's not meeting the question that's asked, and that is for a range and some predictability.
I agree with Delegate Bartlett. I think that is the purpose, to remove the ability for them to recover damages. And I think, you know, the Office of the Attorney General is a funded, funded organization. This isn't like it's a private attorney. Now a person who may be indigent otherwise would have the ability to have their litigation paid for. This is the Office of the Attorney General. So if one of these cases is found to be successful, you could already have injunctive relief. So I think the concerns of the Chamber, frankly, is that the Office of the Attorney General is, frankly, not going to be cheap, so the fees here could be extraordinarily high in addition to whatever damages or injunctive relief they have to pay. And seeing that it's the Office of the Attorney General, which is, a public position that is funded by the taxpayers, I think that was the purpose of the amendment, and frankly, one I support.
Little different order. Kaufman, then, well, okay. I was going to try and do something else, but Kaufman, and then Munoz, Cardin, and Phillips.
A couple points, and this is not easy to say because of the platonic affection that I have for the sponsor of the amendment, but I urge, at least I made the chair laugh. But I urge the committee to, come on guys, I'm making a serious point here, so. I urge the committee to reject the gentleman's amendment because I really, in looking at this, the letter from the Chamber of Commerce, I really have no sympathy because they're talking about, it's going to be extremely costly and it is going to be extremely, costly. Well, I don't have any sympathy for that because a lot of the laws in question, like the ADA, is 33. The ADA is 33 years old. The Civil Rights Act of 1964 and the Fair Housing Act of 1968 is even older. So businesses have had ample time to comply. So and I also resent their use of the word frivolous lawsuit because of the fact that I once heard a lawyer say every lawsuit's frivolous until it's yours, and I do not think the Attorney General would take on frivolous lawsuits because, frankly, it would affect the reputation of the office. Lastly, I would just say that Delegate Valentine made an interesting point about the fiscal note, because the Schmidt Amendment will make it will make the fiscal note worse because of the fact that instead of putting the cost on the wrongdoers, the taxpayers will be responsible for eating some of the cost of the misdeeds of others. So with that, I urge the committee to resist this amendment.
Thank you, Mr. Chair. As both an attorney and a business owner, I have a couple of statements and then I have a couple of questions, I think, for our council. Just to respond to our previous delegates' comments, I think we should all remember that the AG's office, like every other office in government, is made up of people, and people are always, always fallible. And writing blank checks for unlimited power is a very dangerous game. And so that's why we're here to put limits on all of us, because we're all human. And so my question is for council, my understanding of the intention of this amendment was to disallow the recovery of investigation and litigation costs in the event that the lawsuit was deemed, it was either, I believe there's two instances. It was settled or the business or whatever in question won the case. And is that not, I thought that was the original intention, but this is removing it. So whether they win or lose, this amendment is saying they get no investigation and no litigation costs? So if they settle or win, then this amendment is getting rid of the AG's office to then collect.
If they settle or win.
So if you win a case, why would you have to pay the opposing party for bringing that case against you?
And I think that's the broader policy issue here. And one of the questions that was raised yesterday was, are there other situations where the Attorney General can recover costs for an investigation or a lawsuit? And yes, there are cost recovery provisions that are common among statutes that allow for the affirmative civil litigation here. In Maryland, the Consumer Protection Act allows for it, and I guess the argument is, if we allow it for consumer protection, why wouldn't we allow it for civil rights or constitutional claims?
So if someone sued my business using the word our friend used on a frivolous claim that had no merit, and the AG's office took the time to investigate it, my business was found completely innocent, I would then be required by the statute we're about to pass to pay their, oh, if I just,
Only if they lose. I'm sorry, only if they win. If they win. If the Attorney General were to lose in that situation, then no, you wouldn't be liable for the costs of them bringing the investigation against you.
well, that was my understanding what this amendment changed in this bill.
What I see in the amendment, what I see certainly from the intent, what I got from hearing from the Chamber of Commerce and hearing from Delegate Schmidt was that the goal of the amendment was to strike the costs of investigation as something that they could request as part of a settlement or verdict effectively after they win. I'm not familiar of places that get money after if a case is brought against you and then they lose. You don't get that. So,
Okay.
no.
So it's just the settle piece.
So it's the settlement or whatever conciliation after the case is done.
And do we have any statistics on how many meritless cases settle?
Generally, we have a 90-day session. We could try and figure it out. I
Sounds like
honestly,
a work group.
no, no, thank you, no, thank you. But having said that, we don't. I mean, the cases that are frivolous and settle, I don't have a number for that. I don't. I know that there are cases that are already brought before the Civil Rights Commission, and they do work in those areas. I don't know how many. There are surely some that turn out not to have been sustained. But having said that, I mean that also I think goes to the reality, at least as I see the fiscal note, of what is going to be a department of the Attorney General's office that's going to have 6 whole pins, 6 positions that they're going to have to pick and choose what cases they're going to choose to go forward with, and they're going to want to go forward with the most egregious cases as opposed to frivolous cases. Mm-hmm. So part of what they do and what anyone in a public sector position does when they have to choose what they're going to go forward with or not, with the exception of the Office of the Public Defender, because they got to take all their clients. In these cases, you have limited resources and you've got to direct them appropriately, and that is what that serves as a brake on suing everyone.
So they can only ask for it in a settlement situation. They're not required, because then my other concern would be, as attorneys, we always have to have that conversation about the costs, and sometimes the cost to settle something is cheaper than the cost to litigate it. But if you're adding on investigation costs, that might increase our litigation.
But that would be part of it. If you're getting into a settlement agreement, that means you're going to come together on everything, and that would be inclusive of these costs. They'd have to agree to take on some of the costs or not.
It's not required.
It's not. It's a may,
Okay.
and so they can do it. It doesn't mean they have to do it.
Okay.
Yeah.
Thank you.
Carden Phillips.
Mr. Chair, thank you. Actually, that last comment answered my last question. So just to go back, if the AG's office is set up and they investigate and litigate a claim, only if they're victorious after the litigation will they then be able to get these fees for the investigation and litigation. Okay. However, if there's a settlement and there's no claim of fault, or there's no fault established or no liability established, they still may be able to receive, even if there's no assumption of fault.
Yes. If they enter into a settlement agreement and that's part of it, then yes.
Okay.
So it's possible that they don't accept faults, but they enter into a settlement agreement that may cover some part of the Attorney General's
Okay.
costs.
But that's all part of this negotiation.
Right.
Okay. So the attorney's fees are subject to the same reasonableness standard that attorney's fees would be subject to in other litigations. So a judge would have to approve it and say, if they say, we get $10 million on a $3 million suit, the judge would say, no, that's not reasonable. 15% would be whatever, $1.5 million. Okay, so there are some guidelines and guardrails in this already that's established in law. And then the other question I had was, what if the Attorney General chooses to hire outside counsel to handle this, which I think they would be allowed to do? If we pass this amendment, would we be basically handicapping the Attorney General from being able to do that because there's no incentive for an outside firm to come in and handle it because the fees might be reduced significantly?
I think that's an argument. I think that in some, and you can see this in at least in some parts of the country and maybe in the tobacco settlement, which again is not perfectly analogous to this, but there was outside counsel that was hired there. Having said that, I don't know if there was a similar thing there, or whether the Attorney General's office just entered into an agreement with them to allow those costs to be covered. So, yes, but again, if it were coming to a settlement, then they'd have to negotiate that out and agree it. Agree it at that point.
Thank you.
Delegate Phillips, then Delegate Grammer, then Delegate Bartlett. And then I'm going to ask Delegate Schmidt if he's pressing his amendment, and we'll move on. Delegate Phillips.
Thank you, Mr. Chair. From my perspective, this conversation or argument, based on the fact that we do this in the Consumer Protection Act, and this is modeled in many respects after that, does not have the same level of merit from my perspective, because we're already doing this. This isn't different. This isn't new. The objective of this work is to hopefully influence people not to do these types of acts, because if they do, they might be subject to this litigation. If we take out the teeth of the litigation, it also removes the deterrence. I think it's important to have this type of deterrence. And so I would not want to remove the teeth of the bill. I know as a practicing attorney, when you look at a contract and if there are potential damages for not doing something correctly, you advise your clients, don't screw up. Don't do it. And if you don't do it, then you're not subject to it. So while I appreciate the chamber makes that decision, or members of the chamber and business people make those decisions every day based on understanding the rules. And so if we lay these out as the rules, everybody understands the rules, and we adapt to them just like we do any other requirements of a contract or of a business practice. My perspective.
Are you okay? Delegate Grammer, then Delegate Valentine, then I'm going back to Delegate Schmidt to ask him if he's pressing the amendment, and then we'll go from there.
Yeah,
Delegate Grammer.
briefly, thank you, Mr. Chair. So I just, my problem with this portion of the bill is that it's frankly just deleterious to a person who's ruled against. Under the bill, you can already get injunctive relief. You can already get damages. We're talking again about the Office of the Attorney General, which frankly, it's a function, it's a government function, taxpayers pay for it. If they need more staff, that should be something this committee should be consider. I would consider the way that recovery of fees happens in other cases, and frankly, in a lot of cases, it's to give people access, and if someone's willing to take on the case, that they can recover fees. Here, it's, you know, the Office of the Attorney General is not going away. They are funded, they are well-staffed, and look, if I have, let's say, for example, 4 rental properties, I'm a private person, you know, small business owner, and it's found against me legitimately or non-legitimately, or I have to settle because, frankly, I'm about to be ruined. If I just want to settle and be done with this and agree to some things that the court may order, just for clarity of the operation of my business, if I want to settle and I'm fine with the requirements of the court, now you're subject to attorney's fees from the Office of the Attorney General, which I could only estimate are going to be really, really expensive. So I think there are a lot of remedies in the bill already. The fact that we have injunctive relief and damages there currently, I think that's enough. This is a little bit different than other, I hear the arguments about the consumer protections, but this is going to apply, frankly, in a lot of cases to small business owners. That's why it's a little bit different, and that's why I make the case for the amendment.
Delegate Valentine, then Delegate Schmidt. Delegate Valentine.
Thank you, Mr. Chair. The one question I have remaining is, we've talked about recovery of fees and recovery or fines or whatnot if the case is settled or found to be against a business. What types of relief does that business have if they win this case against the Attorney General and his office for a claim that is not found in his favor or that office favor? They will be able to seek that or some type of relief?
Delegate Bartlett.
They can get attorney fees, they can get any other economic damages that they may have. So hopefully that answers your question. But they can get attorney fees, they can get their investigation fees or any other expenses that they might have incurred. Related to that.
Investigation fees, I mean, they would be the people being investigated, but having said that.
Well, I mean, for their defense, I mean, they could lump that all into their attorney costs because it would just be, fees and costs.
Okay. Delegate Schmidt, you're pressing your amendment.
Pressing the amendment, please.
Pressing the amendment. All right, it was moved and seconded. Briefly on the amendment, yes.
Thank you, Mr. Chairman. I just want to be clear. This is funded by taxpayer dollars, and in the settlement, even though the Attorney General's office may have a large pool of money, they're actually using the taxpayer dollars. So why wouldn't we want the taxpayer dollars to be replenished into that pool?
And I think that's what the bill does. That's what the bill does.
Under the settlement?
Whether it was settlement or wherever, it would go back. In fact, I think there's a fund created here that in part takes some of the money and can go back into the fund to help pay for that.
Or
if it's a may.
Right.
It is a shall.
It is a shall. Okay. Thank you, Mr. Chairman.
Thank you. Delegate Schmidt is pressing his amendment. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6. Anyone opposed to the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. The amendment is rejected. We're now on the bill as an amendment, as amended previously. Is there further discussion on the bill as amended? Seeing none. The Vice Chair? Yes. Munoz?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? No, it comes from the Attorney General. No. So Tolles is a yes. Schmidt? No. Simmons is excused. Boucher? No. Phillips? Yes. Tomlinson? No. Erican is excused. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. The motion is adopted. Thank you all very much. We will be back here next week with bill hearings on Tuesday, voting sessions certainly on Tuesday, and expect further voting sessions, and a couple particularly long days, Tuesday, Wednesday, Thursday. Thank you all very much.